in the matter of Matthew versus Ned Sanders, file number 17-02436. Council appearance.
For plaintiff Lapku, Tim Smith, P48259. Good afternoon, Your Honor.
Good afternoon. Let's see, where's Mr. Sanders? He's right here. You can come up to the table here. And please state your first and last name, sir.
Ned Sanders.
Ned Sanders. Okay, today was the date and time set for debtor's exam. And Mr. Smith is advised that there has been a resolution. Mr. Smith, you can put the terms on the record.
Well, thank you, Your Honor. We completed the Q&A part of the exam. There are some documents that I'll get in writing that are owed in response to your subpoena. I'll get those in writing to Mr. Sanders. He'll get those to me in the next 30 days. More importantly, there was a wage assignment agreed to during our discussion. He gets paid on the 1st and the 15th of each month and has agreed to a $125 per paycheck wage assignment. I'd like to, once it's on the record, I'd like to prepare same and submit to the court.
Very good. And Mr. Sanders, that's your understanding as to how you want to resolve this matter?
Yes.
Okay. Do you have any questions for the court?
I do not. We had a pretty thorough meeting. I believe we went over most of everything.
Okay, very good. Okay, so Mr. Smith is going to prepare the paperwork to be filed with the court. You said you're going to send that paperwork to him, or did you want his permission on the record for you to put his signature there?
Permission on a record for me to sign on his behalf so that I may submit straight to the court.
Okay, so he's going to prepare paperwork indicating that you are agreeing to this wage assignment. Are you, and the amount that it will be for, are you giving him permission to sign your name to that agreement so he can file it with the court?
Yes, I am.
Okay, do you have any questions?
No.
Any additional matters for the record, counsel?
None for plaintiff. Thank you, Your Honor.
Thank you. You're all set, sir.
Thank you.
Thanks, Ned.
Welcome.
Okay, and Charles Wisely did not appear. This was for show cause.
Your Honor.
Bench warrant.
Yes, yes, Your Honor. Bench warrant be requested by plaintiff for non-appearance by defendant for bond consideration purposes. Balance remaining on the judgment $4,947.03.
25% is the bond.
We will prepare same and submit. Thank you, Your Honor.
Thank you. Okay. On the record in the matter of McLaren Greater Lansing versus Tiandra Gill, file number 17-00561. Appearance for the record.
Yes, Your Honor. Peter Eshek on behalf of the plaintiff.
Today was the date and time set for a motion or an objection to set aside installment payment plan, but we don't have Tiandra Gill here.
For this record, Judge, this objection was filed about a year ago, and Ms. Gill was on family leave, and we put this off on December the 28th of 23 to today, thinking that she would no longer be on family leave. We'd ask the court to find the objections invalid.
Yeah, my note from December 28th, 2023 indicated that the defendant was, failed to appear, but she was on FMLA at the time. It was extended and she provided information to a plaintiff. There was hope for a possibility of an installment payment order, but nonetheless, she's failed to appear. I'm going to deny the objections, and there's an order that's already in our file. I'll sign and date that for today.
Thank you, Judge. We appreciate your time, sir.
No problem. You're all set.
I do have one other matter, Your Honor.
Thank you. Let's see. On the record in the matter of McLaren Greater Lansing versus Marion Dean Miller, file number 18-01841 GC. Appearance for the record.
Yes, Your Honor, Peter Ashek on behalf of the plaintiff.
So it was the date and time that was scheduled for a discovery hearing. And it looks like the last time this was scheduled, the defendant didn't appear till late, but the defendant has failed to appear today. How did you want to proceed?
Yes,
You
Judge,
want to show cause to issue?
we'd prefer a warrant, but if the court please, we'll be happy to do an order to show cause.
Well, I do recall, there was a January 30th, 2020 hearing, and it looks like the defendant appeared late. The matter was set for 1:30, and there was a motion or objection at the time. I don't believe. Have you had a creditor's exam on this already?
I'm sorry, Judge, I didn't understand.
Have you had a debtor's exam on this already?
I don't believe so, Judge.
Okay, so then no, we will not grant a warrant until after they fail to appear for a show cause.
All right, I'll be happy to prepare an order to show cause. Should I do that on a 7-day notice of presentment, Your Honor?
Yes, please.
All right, I'll be happy to do so. Thank you for your time today, Your Honor. Appreciate it.
Thank you. Have a good one.
You too. Bye now.
Okay, Mr. Holberg, on the record in the matter of Robert Holberg versus Brian Williams and file number 24-01199. Yes, please. State your name for the record, please.
Robert Holberg?
Okay, Mr. Holberg, this was a motion to set aside a dismissal. Is that what this was?
Yes, Your Honor.
Just a moment. Are you able to tell us why we have a fire alarm going off here? Okay. Okay, and this was a landlord tenant matter.
Yes, Your Honor.
Okay, and it was dismissed.
Yes, the day of our hearing, I think it was April 10th, you said bring down a default judgment, which I did. Took the civil desk, and somehow it got lost. And then when I got online to check my writ after the writ date, that's when I realized, seeing that it had been dismissed.
I wonder how it got lost.
I have no idea. One of the court officers for one of the other courts was in there in the civil department at that time. And she said, Bob, I can't believe you're still bringing down in paper. So I did it. So make sure everything was right. And I don't know that lady's name. That saw me here that day.
Let me see, Mr. Holberg. Okay, so we dismissed it for lack of progress. I do see where there was a default from April 10th. Yeah, but last name, I don't know who that is. Okay, someone from civil would have been the one who indicated to me that there was no progress for me to dismiss it. So I don't know who you spoke with. And nonetheless, I do see there was a default. It would have been dismissed simply because I was never provided with the paperwork. So I'll set aside the paperwork or the default. You have the paperwork today?
I do. I have the original one, for a copy of the original one. And then I also made up some new ones for today's date with a different amount.
I'm sorry, today's date with a different amount?
Well, yeah, well, that was the amounts owed when we came to court in April.
Correct. That would still be the amount that you would be entitled to. You would have to file any further eviction process for any amounts accrued, but the default is as of the date of this eviction. Let's see. I do have to change these. Where did I dismiss this? I'm assuming the property is not vacant still. Is that the issue?
Yeah, he was still living there.
Okay. Today is the 17th.
Yes.
I'm going to grant immediate eviction just because of the circumstances. Get you a copy of that and you'll be all set. Okay, sir?
Okay, thank you, Your Honor.
Thank you.
All right, thank you.
Oh, yeah.
I almost.
Okay, so. I'm really not following. Did the attorneys come for LVNV? Colston. Okay, Colston is here for LVNV funding? For Colston?
Yes, Your Honor.
Okay, the record in the matter of LVNV funding versus Annette Hill, file number 23-06226. Counsel, your appearance for the record.
Amy Colston in limited appearance for LVND.
Okay, looks like this matter was scheduled for a motion for summary disposition. It was scheduled for 2 o'clock. It's 2:42. No one has appeared for Annette Hill. Your motion will be granted by default judgment.
Is that with or without prejudice, Your Honor?
That is without prejudice.
Thank you, Your Honor.
Thank you. Did you provide an order already?
I am not certain. I believe there is an order, actually. I think I saw one in the file. I can pull that up. Sorry, I have to do this on I have documents on my tablet and I'm doing the live, I'm doing the Zoom from my phone. Yes, I do have an order prepared. I'm assuming the court's received a copy. We're at 8. I'm sorry?
I'm double checking in my electronic file here.
Okay. Just let me know whenever you're ready for numbers, Your Honor.
I don't see an order. We don't have an order. You can file an order through my file,
Okay.
and I'll sign and review it today.
Thank you, Your Honor. Do you still want me to give you the rundown of the numbers for the record?
Yes, please.
All right. We have a balance of $846.46. Costs including a filing fee of $55, a motion fee of $20, service of $45.07 for a total cost of $120.07. Then we have a statutory attorney fee of $20, which brings the total to $931.53. We have waived statutory interest from the filing of the complaint to the date of judgment. However, the statutory attorney's fees are, right, that's another document. That is, the post-judgment interest rate is $5.39. And I think that covers everything.
Okay, sounds good. Again, you can file that order through my file. If you file it today, I'll review it and sign it. Otherwise, if there's a delay, there's going to need to be under the 7-day rule. Because if I do it today, I'll do it right when I get it. Okay.
Okay, I can't promise it'll happen today, but I will let them know.
Okay, that sounds good. Any additional matters for the record?
Nothing, Your Honor. Thank you.
Thank you. You're all set.
Thanks. Bye-bye.
On the record in the matter of Edward Rose Associates versus Anita Jackson, file number 24-00672, council appearance.
Yes, good afternoon, Your Honor. Doreen Hoffman on behalf of the plaintiff in this matter. And Your Honor, I believe you should have a copy of the consent judgment that was forwarded to the court earlier today. And I just wanted to confirm that we did have that agreement with the defendant in this matter.
It was forwarded how?
I know my staff said they forwarded. Are you an e-file court? Otherwise, I would have said e-file.
We are e-file court.
I was told it was forwarded to you, so.
No, I don't have it, but it does need to be filed on my file. And if it was filed today, there would probably be some lag before I received it anyways.
Okay. I have a second matter with you, which is why I just wanted to make sure that you had received it. That's all.
No problem. So on this one, there was a consent judgment.
Correct. And because she signed it, sent it to a legal assistant. They forwarded it to me, and I know I signed it. And then I was told they filed it.
Okay, I'll note in our system that a consent judgment was completed and it should be filed on my file. If we don't receive it within the next a week or so, the case will be reviewed for dismissal for lack of progress. So please make sure that they file it on my file.
Yes.
Let's see.
I will, and I'll confirm again with them that they did in fact do that.
Very good. I'm assuming this is a. Okay, on the record in the matter of RPM Auto Sales versus Cameron Clark, file number 23-01346. Appearance for the record. Nobody's here from RPM Auto Sales? Anyone here on behalf of RPM Auto Sales? Nope. Okay, no one here for Cameron Clark. Dismissal. This one is an e-file. On the record in the matter of LVNV funding versus Tion Embry, file number 24-00386, council appearance.
Good afternoon, Your Honor. Michael Kirschenheiter for the plaintiff, P75722. How are you?
Well, how are you?
Not too bad.
Pretty, okay, that's good to hear. So today was the date set for a pretrial on this matter. I don't see anyone present for Tion Embry.
I'm right here.
It's there, Judge.
You hear me, Anna? Hello?
I can hear you. The reason why you need to start your video, then you'll pop up on my screen when you speak.
Hold on, I'm trying to. Did it do it? Yes, I'm trying to do it. Unable to access the host. Start your video. Start. I don't. I'm new to all this.
Okay, Mr. Kirshen, did you meet with him already?
We have not spoken, Your Honor.
Okay, I'm gonna put you in a private. I'm gonna put you all in a private meeting room so you all can complete either a joint pretrial statement to be filed with the court, or you can come to a resolution if you're inclined to do so.
Thanks, Judge.
No problem. On the record in the matter of Lake Trust Credit Union versus.
Oh shit.
Mr. Embry, did you receive a request to join the breakout room?
I'm trying to figure this out real quick still. I'm trying to.
I sent you a request to join the breakout room. You need to accept the request.
Okay, show me how. Okay. I'm trying to see if I can. Okay.
On the record in the matter of Lake Trust Credit Union versus the Darlene Berry Gilwell, file number 24-00788, council appearance.
Yes, good afternoon, Your Honor. Doreen Hoffman on behalf of the plaintiff, P42231.
Okay, and I don't see anyone present on behalf of the defendant. This was a pre-trial scheduled for 2:30. It's 2:52. Counsel, how did you want to proceed?
Well, there is counsel on the other side, Your Honor. And generally, the first time I meet with on a matter with a co-counsel, I hesitate to take a default judgment because that just means we're going to get a motion to set it aside and, create scheduling, more scheduling with the court. Is the court inclined to adjourn this to another date and time?
Absolutely, if that's how you want to proceed. I'm not sure why counsel for the defense would not be present today, but maybe they misunderstood. Oh, let's see here. Who is this? No, I don't know. Is that what?
I'm just thinking that it's a credit card debt and that if we have an opportunity to speak, we might be able to resolve it as opposed to, taking a default judgment. And so,
we'll reset this matter and see if you all can make contact with each other. July 1st
Okay.
at 2:30. July 1st at 2:30.
July 1st, 2:30. Okay, thank you.
Thank you. You're all set.
All right, have a nice day.
Same to you. Okay, on the record in the matter of BCG Equities versus Julia Dawson, 24-02173, council appearance.
Good afternoon, Your Honor. Attorney Richard Stuckoff appears for the plaintiff, BCG Equities, P85814.
Okay, and Ms. Dawson is present. Can you hear me, ma'am?
I can hear you, yes.
Okay, please state your name for the record.
Julia Dawson.
Thank you. Today was the date set for a pre-trial on a general civil matter. Counsel, did you all meet privately already?
We have not, no, Your Honor.
Okay, so I'll put you both in a private meeting room. That way you can discuss the case and either come to a resolution of the overall case, or you can create a joint pre-trial statement to be filed with the court, okay?
Okay.
Okay.
Your Honor.
Yes.
We have a resolution on LVNB and Embry, but I'm guessing he needs some help coming back in.
Okay, Mr. Embry, did you figure out how to start your video?
Not yet. I still haven't learned how to do it. You hear me?
I can hear you, yes.
I think what I did when it said, do you want a video and record? I must have pushed no, because this is my first time doing Zoom.
Okay, yeah, there should have been an option for you to start your video versus video recording. That's a different option.
Yeah, and it's still saying, okay, it says the host has asked you to start your video, and I say, and I'm pushing start my video, and then it says unable to access camera, please allow ZoomWork to access your camera from your device, and I click OK, and it still ain't do nothing. I'm using a tablet, and I don't. This is my first time using it.
Okay. Okay, well, we're back on the record in the matter of LVNB funding versus Tian Embry, and met privately with Mr. Kirschenheiter. And my understanding, Mr. Kirschenheiter, is that you all have come to a resolution. However, I can't proceed if he can't work his device.
Hold on, let me see if I can go on my phone and see. Hold on. Hold on. Let's see if I got Zoom on there too, see if it does it. Hold on.
Okay, off the record. Let's see. Let me see if I can pull this other person back.
I just joined. It's doing the same thing. Oh my gosh, I don't know. You see me now?
I see you now.
Okay.
I do. Okay. Very
Done.
good. Okay. Okay. Mr. Back on the record, Mr. Kirschenheiter, can you place the terms of the resolution on the record, please?
Yes, Your Honor. The parties have agreed to enter into a conditional dismissal. The defendant's going to pay $1,000 at $50 a month. First payment July 22nd. As long as he makes those payments, the case will remain dismissed. Should he default on the agreement, plaintiff would be entitled to a judgment for the full amount of the lawsuit minus any payments made plus the court costs. I could prepare that order and file it under the 7-day rule, and I did explain the purposes of that rule about Mr. Embry.
Okay, Mr. Embry, is what Mr. Kirschenheiter stated accurate as to how you want to resolve this matter?
Yes, I was kind of upset about. I wanted it cheaper because I really didn't want the furniture, but our van closed down. There's a lot of other stuff going on with that and COVID, but I go ahead and go with it.
Okay, and so you understand though that by entering into this conditional dismissal, you're going to waive any of those claims. So you understand that?
Well, I missed 3 days of court because the last time I went to court with these guys, last time nobody showed up and y'all dismissed it. So I'm missing more days out of work. So I'm just trying to get it over with.
I recognize what you're trying to do, but what I'm asking you is that you understand that by entering into this agreement, you'll give up any claim or right to claim that you may be making, or any defenses that you believe you have. Yep, to have the case dismissed under this resolution. You understand that?
So if I don't, what will happen next?
If you don't what? Don't
If I-
understand, or if you don't enter
if I
into
did-
this agreement?
I just wanted to get it over with, so I'll take the agreement.
Okay, I recognize that. So you still have to answer my question, which is that you understand that you're gonna be giving up or waiving any defense or claims that you believe you may have had if you enter into conditional dismissal. You understand that?
Yes,
Yeah, you also will be giving up your right to have a trial on this matter. You understand that?
yes,
Okay, and nobody's threatening you or promising you to give up those rights to enter into this resolution?
no,
Okay, and are you going to give Mr. Kirschenheiter permission to sign a conditional dismissal based on the terms that you all stated here on the record, or did you want to review and sign it and file it yourself?
he can sign it. He can sign it.
Okay, okay, with that being said, Mr. Kirschenheiter, you can affix his signature with permission, and you can file that on my file, okay?
Will do, Judge.
Okay, any additional matters for today's record?
No, Judge, have a great day.
Same to you both.
Take care.
Thank you.
Let's see here.
Your Honor.
Yes.
Yeah, I'm just gonna pay that motherfucker. Almost like she was. $1 a piece. Oh, tired of.
Mr. Embry, do you need help leaving the courtroom?
Oh, hold on. I thought I was. Yeah, how you get out? Just.
No worries, I'll remove you. Okay, I don't know what happened to Miss Dawson, but she never returned to the courtroom. She's not in the breakout room anymore.
Yeah, I don't know. I don't know what happened. I guess the parties did reach a resolution. We're in process of circulating the conditional dismissal.
Okay, so I can do one of the two things. I can reset this, and if you have her contact information, you can get it executed and file it. And then you don't need to appear, or I can wait for her to reappear and we do it on the record.
The first one, Your Honor. I think that would be most prudent. I want to wait till any of the court's time.
Okay, I'll reset this to get as a control date, really, and then if you get it refiled, then we won't need to proceed for the next court date. Well, give me 30 days, please. July 22nd at 2:30.
That works for plaintiff.
All right, thank you.
Thank you, Judge.
Have a good one.
You as well. Thank you.